Hello everyone, I am Robert Allen, your MTSA Mooting Officer. In this episode of Addressing the Advocate, I am joined by an esteemed bencher of the Inn, who has, through his extremely generous support to the work of our channel, become a true friend of the Students' Association. It is, of course, Master Dominic Grieve, and for those who have not yet seen it, Master Grieve led a superb qualifying session on the legal consequences of Brexit, and we will ensure there is a link down below in the space below this video so you can catch that recording. Now, though, Master Grieve is back to shed some light on advocacy. As a barrister who went on to have a prominent role in Parliament, in opposition and in government, going on to become Attorney General, Master Grieve brings a unique insight into what it takes to become a successful advocate, both in the courts and in the Commons. And he joins me to discuss all of that today. Thank you so much for joining me, Master Grieve, and a very happy belated New Year to you.
Thank you very much. It's a pleasure to be with you.
Master Grieve, perhaps it is helpful for everyone, first of all, to set out some context to all of this. Much is known about Dominic Grieve, the politician, but perhaps you might start by telling us more about Dominic Grieve, the lawyer, and specifically your early time at the bar.
I was called to the bar in 1980. I'd read history at university and hadn't been certain at the time I was reading history. It was very much my first love, what I wanted to do afterwards. My father, who was a barrister, was encouraging of the idea that I should come to the bar, but he certainly wasn't prescriptive about it. And in fact, I did do the civil service exams to go into the Foreign Office, but perhaps wisely, they decided that I wasn't the right sort of candidate for them. So that although I got through to the second round, I didn't get beyond it. At which point, I thought that the attractions of being self-employed were ones which would be interesting for me. And I could also see, because I had a political interest even then, that should I eventually do politics, having had a career at the bar would be quite a helpful thing to have done first. And I wanted a proper career at the bar, not just to qualify and then go off and work in a back room somewhere in Parliament. So I left Oxford in 1978. I came down to London. In those days, the available tuition for doing the bar converter course was not very great. There were only two places in the country which did it. One was the City University and the other one was the Central London Polytechnic. And I chose the Central London Polys purely because in transport terms, it was slightly more accessible. And I did my bar converter course for 1 year at the Central London Polytechnic, a course which starts in September and finishes the following September. Right. Without really a summer holiday. And it is really learning by rote, or it was then. I think, in fact, the law schools which now do it have made it much livelier. But in those days, it was a foundation course in law. You had to learn an enormous amount, and I can't say that it riveted me. I don't think it probably riveted the other people who were also doing it with me, some of whom went on to have very distinguished careers at the bar as well. At the end of that, we passed out, or passed through. I'm not sure how you best describe it. I don't think any of us distinguished ourselves particularly. And I then went to the only place then in the country where you could do your bar finals, which was the Inns of Court School of Law in Gray's Inn. So another year of quite a lot of learning by rote, but more enjoyable, and the beginnings of some advocacy training as well. And then, having done that, I found pupillage in a chambers at Crown Office Row with a barrister called Nigel Wilkinson, who was a set of chambers that did a lot of personal injury work. I also did some other things, but it was mainly in those days grounded in personal injury. And I had 12 months there, and they didn't take me on. So I then went and did a third six at One Harcourt Buildings, and which was a very old-fashioned set of chambers, which was generalist in a way that I think has almost completely disappeared now, certainly in London. A set of chambers which had a wide variety of work, one silk at the top only, the juniors beavering away, doing everything from licensing work in the magistrates' court, family law work, lots of general contract and tort in the county court. And there was a connection to Kent and Sussex. So quite a lot of the work took you down to Kent and Sussex, mainly for criminal advocacy of one kind or another, either prosecuting or defending. Now, just to go back a bit, I mean, in terms of enjoying advocacy, one of the sort of background questions which I think you were going to ask me was, had I had an interest in advocacy before I came to the bar? To which the answer is no, not as such, although it's true that as a schoolboy, I enjoyed the theatre, performing in plays, and I enjoyed public speaking and poetry recitals and poetry competitions and things of that sort. So there may have been a sort of already, the pleasure of declaiming may already have been somewhere in my DNA. In my last year at prep school, I won a thing called the Colin Pearson speaking competition. Pearson had been a Lord Justice of Appeal, by then dead. And I was accompanied, he was an old boy of the school, and he'd left a gavel. And so I won this speaking competition. But I don't think I would want to put too much on that, apart from the fact that I did enjoy performing in public. I think there's no doubt about it. But advocacy, I hadn't done that. And the advocacy really started in my second 6 months in the chambers. And the chambers did, as many chambers did then, road traffic cases, mainly for a firm called Amory Parks, which did all the AA's litigation. So for 6 months, I spent my time going around magistrates' courts, putting in pleas in mitigation for people who were being prosecuted for driving without due care and attention or speeding offences, for which you got paid £10. If there was a contested case, then you got paid, I think I'm right in saying £20. And if it was out of London, you would get 30. So that was how one made one's money. And there's no doubt that that is where I started to learn advocacy. Admittedly at quite a low level, because it's magistrates court advocacy, but nevertheless, putting in a good plea in mitigation on behalf of somebody who you didn't want to see totting up and being disqualified, sometimes winning cases, usually on some rather bizarre and esoteric points of law. I remember a wonderful one which involved the size of the road signs and whether they were in conformity with the regulations. They showed a 40-mile-an-hour speed limit, but I was able to establish that, in fact, the road signs weren't the right size. And as the regulations were drafted, because the road signs weren't the right size, the fact this chap had been doing 50, and see, he was the one who said to me, he said, I never saw those road signs. I think they're very small. And I said, well, we better go and have them measured. And sure enough, he was absolutely right. They didn't conform to the road traffic regulation. The police were absolutely appalled. They'd been putting up people for years on these road signs. And all these cases, nominally, I don't suppose anything very much happened, were therefore the speeding offences hadn't been committed. So it was quite knockabout stuff and could be very entertaining, and it forced you also to do a bit of thinking about law and to present, and of course lay magistrates, because it was mainly lay benches, particularly outside of London. There's a bit of discipline in that, how you're going to appeal to them. They may sometimes be rather fixed in their views, and how you're going to make them listen, and whether you can, along with the clerk, persuade the clerk you're right about the law, and then perhaps get them to interpret the facts in the way that you want. Once I got into my third six and then got taken on at Harcourt Buildings, then at that stage, I started doing a bigger variety of work. There were possession actions in the county court, behaviour of landlords who had to be cross-examined, or tenants who had to be cross-examined. There were family law cases, which were usually quite difficult to handle because there's a lot of emotion in family law matters, whether it's about the children or ouster injunctions. And then there was the crime, where, in fairness, probably one's advocacy skills were being tested the most. Travelling down to Kent, going down to Maidstone Crown Court, which had just by then opened. At the very beginning, it was in an old ramshackle building of the old county headquarters, but later they opened a wonderful Palace of Justice where the judge insisted on proper facilities for the bar. Sadly, now, I went down there not so long ago and was horrified to see that although the premises were still there, the facilities were no longer available.
Right.
But that's, I mean, this isn't a complete tangent because actually it's quite important. If you went in the late 80s to do a case in Maidstone, you got there, you could go up to the barristers' mess, you could get robed, you could go in and order eggs and bacon for breakfast, you could have your cup of coffee and your cup of tea, you could meet and talk to your opponent about the case and how it should be handled. And if, as a junior, you were anxious about some point of law or some point of procedure, there was always somebody who would talk to you about it then and there, because there would be 15, 20 barristers in the mess, in and out, some of them obviously not in court because their case was waiting to be called on. And over a cup of coffee, you would be able to talk these things through, something which I think the current bar may have much greater difficulty being able to do. And a sense of collegiality and of standards being maintained. And if you went wrong in court, your opponent would politely pass you a note and say, not very good advocacy. And you had the opportunity to watch much better advocates than you were, I was, performing. And in some of the longer trials, there would be top criminal counsel coming down from London. And you would watch and listen to what they were doing, how they were handling difficult witnesses, how they were trying to get their points across. You'd pick up pretty quickly whether they were behaving well, and some of them did, and some of them occasionally weren't behaving so well. You know, can't ignore that. And how to handle a judge who's very difficult. The answer is you should always say yes or terribly sorry. And then if you think he's wrong, you just carry on really slightly as before. It's always until you get stopped again, then you apologize profusely unless you think he's right, in which case you shouldn't be doing it. And you should be moderating your position. But it's all about communication. Communicating with the witness, trying to marshal your thoughts as to what the key issues, points are that you want to draw out of an examination in chief or a cross-examination. And cross-examination is always really more difficult. But once you've got those points down, you know, what's the best way of tackling this? Is it to be confrontational? Is it to try to gently relax them because with some completely anodyne questions and then just gradually draw them out? And what are you dealing with? Are you dealing with somebody who's very frightened? Somebody who is extraordinarily nervous, very angry? What's the best way, and what is it in a way that you want, particularly with a jury, what is it that you want to bring out about this person in the course of examining or cross-examining them? And that, to me, is the essence of the advocacy in terms of the examination of the witnesses. Of course, linked to that, there's then, particularly in criminal trials, less so in civil, but in civil you're still likely to have a closing submission. But in the criminal trial in the Crown Court, you've got your closing speech to the jury. And that, of course, is a combination of things, because it's a combination of, firstly, you must not be inexact. You know, you've really got to be precise. If you're going to talk about the evidence, you mustn't be slippery. I always used to get very angry with barristers who try to be slippery about the evidence, which had not in fact been given. And judges don't like it, and it's a very bad practice. So my view on this was that you should be very, very strict with yourself, but then you're also entitled to appeal to a bit of emotion, particularly if you're defending somebody, not if you're prosecuting. And as a defense counsel, part of the skill was trying to ensure that you could convey to the jury the importance of their decision and therefore their importance of focusing on it. At one time, I used to do quite a lot of causing death by reckless driving. These were other instructions which used to come from insurers. And they tend to be very harrowing because, I mean, firstly, there was a person, somebody was dead. But secondly, the chances were that your client wasn't a boy racer who'd gone out to do 85 miles in a 30-mile-an-hour limit. And usually they were bang to rights. They were somebody who just had a bad day at the wheel.
Yeah.
And they were honest citizens and they were facing the prospect of going to prison. And there was a huge difference between causing death by reckless or later causing death by dangerous driving. And of course, the alternative, which was simply there was no causing death by careless driving in those days. So if you were convicted merely of driving without due care and attention, it could be a pile-up which had killed 25 people, but you'd only end up being fined £250 because it was considered that the mens rea, your culpability, was very slight, even if the consequences had been catastrophic. So these cases were really, they used to keep me on edge because how could you pitch it to this jury? Clearly they had to decide on the evidence and the judge would get a bit shirty with you if you became too, but you point out to them, this is really serious for this individual. This is the difference between leaving through the front door and going back to your respectable job as a civil servant or a doctor, or whatever else it might be, or ending up in Pentonville this evening. So you've got to try to pitch that right. And that was part of the challenge, part of the thing I think I probably started to enjoy about it. And it's always, like any performance, from start to finish, it's a very adrenaline rush, though I certainly found it so, and quite intense. Civil litigation less so, but actually, even the civil litigation can, you are there and you've got to focus, you've got to concentrate. Always makes me laugh when people complain. They say, judges, they don't sit long hours. Why are they only working from 10:30 to 1 and 2 to 4? Well, the answer is, if you've been trying to follow evidence word for word in every detail for that period of time and that intensity, that's about as much as you can manage. And it's terribly easy to miss something or drift off. So you've got to be completely and totally focused on what's being said.
And when you talk about the idea of pitching a case, do you think that that is something which it comes with instinct and is developed through experience? Or do you think there are any techniques that you have learned or you have seen that can help you do that quicker?
I certainly think that you learn on the job. And you learn by watching other people as much as by judging your own performance. I think that that's pretty key. And I think that that is very important. You can also, there were books around, The Art of the Advocate. There was Richard Ducan's book, which was always used to be well thumbed by young advocates. I don't know if it's still around, but that was about the art of the advocate. And it was certainly worth reading, and there may be some more recent works, but that was the one I read.
There's a copy of it here.
There we are. Well, you learned something from it, and Richard Ducan was a very, very considerable advocate. He was a very able man and very well respected. And there were some other advocacy books around written by barristers, particularly aimed at the junior bar, the people just coming in, and I'm sure there are some around today. Of course, some things have changed. So much more is now being done in writing. The requirement for skeleton arguments. When I started at the bar, you went off to do a case, it would be regarded as quite eccentric if you handed in or exchanged skeleton arguments on a civil case. Criminal cases, statements of the defense case. I mean, these were unheard of.
Yes.
So there was much more was dependent on what was actually being said and done in the court setting. So I think I learned on the job. The more I did it, the more I learned and the more I enjoyed it, and the more I watched, above all watched. The great thing, I think, if you're a junior barrister is, or even a pupil, if there's a chance of being a second junior, along with your pupil master and going into court and actually watching a case which involves, it can be civil or criminal, but involves the examination of witnesses, involves a lot of law, and just watching how that's done, I suspect you will learn much, much more than from reading a book. And of course, you can go and do it yourself. You can go over to the High Court if it's sitting, difficult at the moment, and watch.
The challenge.
You can go into the Crown Court and the back and sit at the back and just watch it being done. If you can find a case which is involving advocates of skill. And let's face it, maybe now sounding sort of old and old-fashioned, but there's a lot of lamentation on the bench, which I picked up when I was Attorney General, and I don't think it's gone away, that standards of advocacy are deteriorating. And that a lot of people don't seem to understand the distinctive nature of it as a skill. And even though they may have qualified for the bar, they're not very good at doing it, to the great frustration of judges. And of course, there's the added problem that when you're dealing with lots of civil cases, increasingly, if you're in court at all, you may well be having a litigant in person against you. And that then imposes on the advocate barrister a whole series of responsibilities about fairness in presenting the case, which won't necessarily arise in quite the same way if you are dealing with a qualified opponent, advocate, barrister, or solicitor. So the bench then becomes very dependent on barristers being absolutely clear, precise, and fair in the way they operate. And so that's an extra challenge, which I think when I started at the bar, I mean, the number of times you encountered a litigant in person was very, very few. Yeah, but nowadays, my understanding is it's quite common.
Why do you think it is that standards are dropping?
I don't know. The bar has expanded a lot. And whether as a consequence, there's a greater problem in people getting pupilages in chambers where they're going to get the right sort of experience, query. So much with this sort of thing is about generational acquired knowledge being handed on and passed down. And if an organization or like the bar expands very quickly, then it may be that some people aren't getting the benefit of it. And I was very lucky because my two sets of chambers, the first one was very much civil orientated, but the second one was, as I say, a very old fashioned sort of chambers, not without some difficulties in terms of career structure and the lack of, but it had a single silk at the top, but there were experienced juniors. They knew their stuff. And as I say, they were also part of this wider circle, certainly for the criminal work. The Kent Bar Mess was regarded as being a model bar mess, precisely because it was mutually supportive and people talked to each other. And somebody would say to you, you made a mistake in court earlier. They'd be quite blunt with you as you had lunch. You shouldn't have asked that. You should, or I'm sorry I picked you up on that, but it's not a proper question. So people weren't slack in perfectly politely continuing your education as a junior member of the profession, whilst doing it in an extraordinarily convivial and pleasant fashion.
Yes, yes. And particularly difficult now, given that all of my advocacy training and that of my peers this year online, you can't have those informal conversations around the sessions with your tutor or with your peers and really be honest about where you are, because you're just logging into a computer screen, delivering your advocacy, getting some feedback, And unfortunately, that's just the way of it at the moment, but it makes it even harder again, I think, to really get to grips with what it is to share your ideas about advocacy.
Yes, I think it's going to be extremely difficult, and doing advocacy training online, I would have thought is pretty difficult. You want to do it with other people in the room, and you want to get the feedback. And we already know that whilst there are attempts at maintaining the court system through doing it virtually, it can't be done for a serious case. You've got to be able to eyeball the person whom you're asking questions. Mm-hmm. So we've got to hope that this goes back. But I would like to urge those who are watching this not to despair about this. Everybody makes mistakes, and when they start in advocacy, the great thing is to be alive to one's own shortcomings and how much you need to learn. And then if you do that, I think you will find that you start to pick things up very quickly.
Yes, yes.
And doing mooting, obviously, which the Inn offers, and I've enjoyed judging moots. I mean, mooting advocacy is slightly different because it's points of law, but nevertheless, that too requires you to stand on your feet and to work out and articulate an argument which you can present in a clear fashion, often from really complex material.
Yes.
And that's the other thing, isn't it, about the advocate's art. Advocacy is in part taking a complex issue and being able to break it down so as to present it with clarity. And that applies, obviously, with criminal advocacy, presenting fact rather to the jury, or civil advocacy, whether it's examining the witness, but actually doing submissions on complex points of law, making that intelligible so that you've got a coherent series of points that you can put to a judge, that the judge can then say, I've got that. Now, he may, having got it, decide he disagrees with you. But the thing that you've got to try and do is to make sure he gets it.
Yes.
And sometimes, fortunately, the judge will have got it long before you came into court. But then that can be a drawback because maybe he's unshakable in his view. And whether you're doing advocacy in the Crown Court or whether at the end of my career, you end up doing advocacy in the Supreme Court, it's the same advocacy. It's the same issues.
You took your seat on the green benches of Parliament in 1997. How would you say political advocacy differs from legal advocacy?
It differs a lot, and not in a very flattering way for the politicians. My joke was always that if you're at the bar, you got brownie points overall in terms of your career development and the view that the judiciary took of you if you were concise and precise.
Yes. Whereas
there is something which suggests that advocacy in the House of Commons is prolix and obfuscatory. And certainly the obfuscatory nature of political debate and discourse is a very prominent feature. I'll come back to that. That said, clearly there is a great advantage to a lawyer going into Parliament, probably, unless they've been lawyer doing tax law and sitting behind a desk all day, because the point about the House of Commons is that it doesn't like or appreciate what I call set speeches. Front benchers have to do it and will have a text in front of them, but MPs who stand up and read their speeches, it tends not to be appreciated, and rightly so, because it is a debating chamber. Therefore, when you stand up, you shouldn't just be making the points that you had written out to make 2 hours earlier. You should be responding to what the person who spoke immediately before you and is likely to be on the other side of the argument has been saying.
Yes.
And you ought to try to make sure that you can weave that in, as well as referring to points that other people may have made in the preceding hour because you'll have been sitting, often waiting 2 to 3 hours to speak. You ought to be able to weave those points in. And if you start to do that, and you've also got a coherent case to make, people will start to listen to you.
Yes.
Whereas people who just produce the sheet of paper and start reading off it their own thoughts on this, which without any reference to anybody else, are immediately qualified as being boring and tend not to be successful in the sort of theatre of the House of Commons. And the Commons does see informality as being very important, and it's indeed its great strength. And anybody who's ever gone and watched, I hesitate to say this, but the proceedings of the Scottish Parliament will realise that for all its drawbacks, the proceedings of the House of Commons are infinitely superior, because you don't sit at a particular desk, and there is a formality of speech. You know, right honourable, the right honourable gentleman says this, the right honourable lady says that, the honourable and learned member has said X, Y, and Z. But that's all there for a purpose. It's there to, oddly enough, to help maintain a degree of politeness, but at the same time to give it a certain amount of formalized structure to an informal conversation. Yes. So there's this mixture of the formalized, right? Perhaps it's rather like people were supposed to speak at a dinner party in the 18th century. I don't know, but it's got a bit of that to it. But that combination can mean that you can have great speeches. And people can express emotions, and they can say all sorts of things. And great orators in the House of Commons there are, and listening to them, and sometimes suddenly turns into a great orator unexpectedly. And Hilary Benn is a good speaker, but when he made his famous speech about taking military action in Syria, against the wishes of Jeremy Corbyn, he delivered suddenly a very great speech. Yes, it just came across that way because he'd understood the key points. He had a mastery of the points at the fingertips, and of course, all linked to that is the ability to make a speech without any note. Yes. And the best speakers in the House of Commons tend, in my experience, people who stand up and they've just got a card sometimes they're holding in their hand, and they probably never look at it, and the card has got the 4 points they want to make, and then they just get on with it and do it. Yes. So clearly, particularly for somebody who's done a jury trial and has been a jury advocate, as I was, then there are some very great advantages, because most of my jury speeches weren't written out. They would all be headings. And so in exactly the same way, you should be able to do the same thing in the House of Commons. Now, against that, coming back to the obfuscatory bit, is you only have to listen to what ministers get away with at the dispatch box in terms of not answering questions. To see, I mean, if that behaviour were to go on in court, the judge would be absolutely furious, but there's no one to stop it. So you may think you have a killer point to ask the Prime Minister, but the chances are that the Prime Minister, if he has any nous at all, can just brush it away. And that can make people very irritated when they watch Parliament, but there is no coercive mechanism to make ministers answer questions. Although there are ways in which you can put them on the spot so that the failure to answer is noticed. One thing is to team up with somebody else so that you ask the question repeatedly and you're still not getting the answer. That can be quite, but you need to find somebody else to help you do it. But I enjoyed the House of Commons. I enjoyed the debates. And I think I also enjoyed, interestingly, the work that isn't seen and a lot of MPs don't like doing, which is working upstairs on a bill committee. Yes. A bill committee is a minute examination line by line of a piece of legislation. And the committee will be structured so the government has a majority, if it has a majority in the House of Commons. Most of the MPs who attend will be bored stiff and will actually spend their time largely with their noses in the looking solely at their correspondence, and will just vote when required to. The minister, however, has to answer any suggestion. He has to explain the bill as it goes through. and it is open to any member of the committee to table amendments. Now, as a barrister, I quickly discovered that actually, if you stayed up for an hour at 11 p.m. before going to bed, you could produce 20 amendments for the following days. Well, it wouldn't be the following day's business, it would be 2 days hence, and table it. And this would, even if the amendments, well, it couldn't be absurd, but an amendment forces the minister to explain what that bit of text actually is.
Yes.
So it's almost a device of cross-examination. And when we did the Proceeds of Crime Act, still on the statute book, a rather important piece of legislation, I think I made a rather notorious name for myself by tabling 315 amendments to it. I was the principal opposition spokesman at the time, but I thought it was a pretty, well, it was quite a hair-raising piece of legislation, actually, in terms of the powers that it gave the state. And I thought it needed to be ruthlessly examined. So I got on with the job of ruthlessly examining it. And as a consequence, 90% of the amendments fell away. They were just debated and never returned to. But we did actually get some quite significant changes to the legislation as it went through, simply because we'd asked questions, some of which nobody had really asked a question about before it had got there.
Yes.
So lawyers, I think, do have an advantage in that context, because particularly if your practice has involved some study of statute law in its interpretation in the court, then I think it offers quite a lot of opportunities to be able to apply one's mind to trying to improve legislation as it goes through. And that's something which many people can't do. Although that'd be wrong to say that non-lawyers can't do it, because you can always go and get help from the clerks of the House of Commons. If you're having difficulty drafting an amendment, you can always go and discuss that with them. But that was certainly one of the, people might have thought I was a bit of a nerd, really. I think sort of wanting to do this work, which most people ran away from, because it doesn't involve journalists, it doesn't involve anything else. I thought it was fascinating.
Yes.
And I really quite enjoyed doing it and trying my hand at it. And of course, I learned a lot, and that too was very useful when eventually I went into government. So all part of that learning curve process of advocacy and presentation of complex facts.
And in your roles in government, I suppose the headline role there is Attorney General, but what particular advocacy did you perform in those various roles, and what stands out to you perhaps as one or two moments where you really had to rely upon both your skills as a politician but also your advocacy skills as a barrister to seek to persuade?
It's an interesting question about the role of the Attorney General, because if you'd gone back 70 or 80 years, you would, the attorney really was a lawyer advocate.
Yeah. So
he had chambers, a couple of rooms in the Royal Courts of Justice, and he had, I think, 3 or 4 clerks who were legally qualified, who provided him with support and assistance. And he and the Solicitor General, who occupied a similar but slightly smaller set of rooms in the Royal Courts of Justice, spent their day arguing cases on behalf of the government in the High Court. That was what they did, or they might go to the Court of Appeal, or indeed they might end up going down to Parliament to the House of Lords. And they would do that from 10:30 to 4 o'clock in the afternoon. And then they would go down to Parliament and behave as MPs, although if the attorney was normal and successful, he would also be going to his room in just off the central lobby of the House of Commons, interestingly, kept separate and distinct from the other ministers of the Crown, so he shouldn't be too contaminated by them, and also within ready access to the House of Lords, where he also actually has a role potentially as a legal advisor to the House of Lords, something which isn't often understood. So when I became Attorney General, I actually got a writ of summons to the House of Lords, personal writ of summons, but not as a peer, but as a sort of advisor. And he would then stay up all night doing some legal advice to the Prime Minister on the matters which the Prime Minister wanted legal advice. And that was his lot. And he was able to charge for his fees for his services, as well as being paid a retainer. And he worked his socks off. Now, all that is now unrecognizable. The volume of litigation has expanded massively.
Yeah.
So that the ability of the attorney or the solicitor, even if they wanted to do this, to go into court all the time, they simply couldn't cover the volume of cases, so they'd have to bring in external counsel. And of course, there were Treasury counsel even then, but there are now lots of Treasury counsel doing government litigation. And in addition to that, the volume of advisory work has soared completely, so that the advisory role of the attorney is irreconcilable with the advocacy role of the attorney, if he was having to handle it all. And what I think has tended to happen is that the attorney has become more and more of an advisory lawyer minister and less of a lawyer advocate. And indeed, some of my predecessors have gone into court very, very little. Although most, perhaps it's a matter of pride, I don't know, most have felt that they should be going into court, because not to appear in court at all is to give the impression that you're a sort of ersatz barrister or solicitor. You could be a solicitor, but I mean, you know, particularly a barrister, but you're not really the real thing. So there's a sense that you really ought to go into court. And of course, going into court is important because the Attorney General is the leader of the bar. Now, that's a nominal role. Now there's a chairman of the Bar Council, but it's still a role where the attorney is seen as being the leader of the bar, and therefore people come and talk to him about problems being the leader of the bar, and seeing the leader of the bar turn up in court and be prepared to face difficult judges. There are very few difficult judges around these days. You know, that's in a sense part of the role. So I found, I mean, firstly, I'd been doing very little advocacy in the 4, 5, 6 years before I got into the got into government. I carried on when I was in Parliament, but obviously it tailed off. And I think I'd done my last piece of advocacy in 2008. So I had a 2-year period where I hadn't been into court at all. I became Attorney General. And essentially, by discussion, most of my role was advisory, going to Cabinet, attending the National Security Council, answering questions in Parliament, principally related to the performance of the Crown Prosecution Service. But there were a number of areas where we tried to make sure, the Solicitor General and I, that we did go into court. The solicitor probably had more options of going into court because his workload in advisory terms is less heavy. And I found I did a number of things. I went fairly regularly into court on Attorney General's references for unduly lenient sentences. It kept me in the swing of, they tended to be the higher profile cases where there was a feeling that the judge had not passed the sentence that was satisfactory, and so I went to argue that in front of the Court of Appeal.
Yes.
I also decided quite early on in my time as attorney that we had to do something about contempt of court, because the press were running riot, really, and completely disregarding the Contempt of Court Act and its principles, and it was endangering criminal trials. So I brought a couple of prosecutions of national newspapers for contempt of court. The Christopher Jeffreys case, Joanna Yates' murder, was the famous one in Bristol, where both the Sun and the Mirror completely traduced Mr. Jeffreys after he'd been arrested, mistakenly as it turned out, on suspicion that he'd murdered this young woman, and published the most lurid and ridiculous stories about him. He subsequently recovered vast sums by way of damages, which he was fully entitled to. But they endangered any future trial would have been impossible, fair trial would have been impossible with this. So I prosecuted them, and I did those myself. I didn't do
Yes.
all of them, but I thought that as a matter of discipline and presentation, I should do them. And so there were probably 3, 4, 5 of them I did in my time as attorney. And linked to that, we also, unfortunately, had to prosecute some jurors for not obeying judges' directions and going off and doing research on the internet. And I had a couple of those as well. Apart from that, the bigger cases mainly went to Treasury Counsel, but I was able to go over and do a case in the European Court of Justice in Luxembourg. I was an intervener in a case in the Court of Human Rights, European Court in Strasbourg. And I had a couple of outings into the Supreme Court, one on a case called Chester and McGeoch, which was about EU law and the right of prisoners to vote, which mattered very much to the Prime Minister, so much that I thought I must go and do this myself. In any case, it was quite an interesting case. It was both about human rights law, but also about whether, in fact, EU law could be made to force the government to change the prison rules so as to allow prisoners to vote in EU elections, in which case there would be an override and the judges themselves strike down part of the legislation. So, of the Representation of the People Act. So that was quite an interesting case, and I really enjoyed that. That was 2-3 days in the Supreme Court. And I had another case on devolution involving agricultural wages, also in the Supreme Court. And I'd have loved to have done more, but you had to ration yourself. But it was exactly the same skills as I required way back in the magistrates' court, or for that matter, in doing the Kent sessions, as it was then called, down in the Crown Court in Maidstone. The only thing, and attorneys general have to probably don't want to admit this, but you, as Attorney General, if you go into court, you are immensely well supported.
Yes.
There will be a junior, certainly if you're even doing an unduly lenient sentence, who knows everything about the case. And if you're doing a very big case like Chester and McGeoch, you will also have Treasury Counsel, probably a silk alongside you. The case will have been absolutely crawled over and prepared to the nth degree. Every conceivable point of law that might come up ought to have been looked at. So as Attorney General, you can get on with the advocacy. You don't have to do that with that terrible sense in your mind, have I missed something? Because you shouldn't have done with all this excellent preparation. So it's quite a privileged form of advocacy to do.
Yes.
But immensely rewarding. And I'm really sorry when it came to an end. It was one of the things I missed, because it was good for me, and I think important it should be done.
And when your time in that role did come to an end, that was over a dispute about Strasbourg's role, was it not? How did you seek to persuade the government? You were advising the government, but what was your role in persuading the government of your legal approach to the court in Strasbourg, and how you felt they should consider the issue of human rights?
Well, that raises a very interesting question. The difficulty, I think, that arose and which led to my departure, and it may have been, I've got to reflect on these things, it may have been partly my own fault, is to what extent do you go along with a proposal which you think is firstly, in a way, absurd and unrealizable, in the hope that its absurdity and unrealizability will get to the point that further down the track it will be abandoned. Dare I say it, we've seen that for law officers, and possibly for the Lord Chancellor as well, recently over the Internal Markets Bill. They can say, well, at the end of the day, nothing terrible happened with the Internal Markets Bill. The United Kingdom didn't breach its international legal obligations, but there is an argument that no Attorney General should stay in office when you introduce into Parliament what is a flagrant breach of international law, which the government has promised to uphold. Discuss. Very, very difficult issue. So,
I'll leave that one to former Attorney Generals.
In my case, going back to 2014, David Cameron had a bit of a bee in his bonnet about the European Convention on Human Rights. And I can understand that. At times it's been rather irksome for government. There seemed to be a constant refrain in the Conservative Party that we should scrap the Human Rights Act and replace it with something else, which was designed to give us greater wriggle room so that it would be interpreted here differently from the European Convention on Human Rights. We would try to use our margin of appreciation and end up with subtly different outcomes. And my view as a lawyer was that in practice, this was going to be very difficult to achieve. And indeed, there's a new commission looking at exactly this all over again. And I'm prepared to hazard a guess that they're going to be forced to come up with largely similar conclusions. Now, that doesn't mean you can't do anything, but it's going to be in practice largely cosmetic. Because he was frustrated with that reality, he then started suggesting in 2014 that he wanted to put in the Conservative Party manifesto of 2015 a proposal which was again to scrap the Human Rights Act and replace it with the British Bill of Rights, which would interpret the ECHR better, but with the implied threat that if for some reason that interpretation then fell foul of the European Court in Strasbourg, the Court of Human Rights, we would then uncouple ourselves from the convention, or be prepared to do so, or defy the convention, or not observe our obligations.
Yes.
I made quite clear that I was very unhappy with that, and I thought this was a mistaken approach for a UK government to adopt, where you are, proclaiming that you believe in an international rules-based system. Now, it never came to a crunch, but I think that the Prime Minister, being aware of my views, and I suspect having been told by Linton Crosby, I think Linton's expression was, it was time for the 2015 election to scrape the barnacles off the hull of the ship, decided that anybody who might be objecting to putting this into the Conservative Party manifesto, who was in ministerial office, probably ought to be moved aside. And so, slightly to my surprise, because I hadn't expected it, he said, look, thank you so much for your 4 and a bit years of service. It's been very kind of you, but, goodbye. And that was it. And he's entitled to do it. In fact, what happened was fairly predictable, which it did appear in the Conservative Party manifesto, although by then their opinion polling had shown that in fact mattered to far fewer people than they'd realised. So it appeared at about page 96. And of course, nothing was ever done about it thereafter. So you can make an argument that I was mistaken in my approach and I should have just gone along with it and said, of course, we can look at this further down the road and we can consider this on new occasions. And I'm sure that a formula can be found, and just let, in a very political way, this whole thing drift. And it might have gone away and I might have remained Attorney General, certainly until 2015. And who knows, I might have remained Attorney General beyond. But because I think I nailed my colours pretty firmly to the mast, that was the end of it.
Do you think there would have been a point there? Obviously, when Brexit then came along, none of that was foreseeable at that time. Do you think there would have been a point when you would have felt, not just in your political principle, but in your legal principle, that you couldn't continue on in that role? When things start appearing in the manifesto, we've quite recently seen Lord Keane resign last year. Would you have felt in a similar position if that were the case with the British Bill of Rights?
I think that if I had seen what eventually appeared at page 96 of the manifesto, then the politician in me would have said, let's wait and see what happens next. I mean, quite apart from anything else, it was perfectly possible that even if I'd stayed as attorney till 2015, David Cameron might then not have reappointed me when he set up his new administration after winning the 2015 election. That's very much within the Prime Minister's gift. The unusual nature of what he did was sacking his attorney at half time, which is not normally done. You can move him somewhere else, but to get rid of him completely is seen as being slightly surprising thing to do. So yes, I mean, I think I could have managed my way through the election. And as I say, I wasn't threatening to resign if the manifesto came out. I think that he probably just didn't want to hear from me again. But I didn't think this was a very good idea. I was rather hoping that having helped him with Chester and McGeoch and given him an outcome which he really wanted and he was very pleased about, and also we got on very well. I shouldn't give the impression that we didn't have a good relationship. We understood each other, and we'd been, I hope I was helpful to him in his time in office. It's a very difficult thing to do, being Prime Minister. But so I think it was perfectly manageable. But no, he just decided that he wanted an attorney who didn't get bang on about this.
And time moves on. We then go to the 2017 to 19 Parliament. And in many ways, it's quite impossible, inconceivable at the moment to imagine seeing the scenes of Parliament absolutely crowded, waiting for a vote. But no doubt it will come around again. But that Parliament was particularly crowded late into the evenings, with knife-edge Brexit votes on the line. And you played an absolutely prominent role in so many of those debates. How did you go when returning to the backbenchers over that important issue? How did you go about seeking to persuade the House of Commons on what was such a fragile and contentious issue of Brexit?
What happened is, obviously, I was disappointed with the outcome of the referendum. I thought, and still of the view, and there'll be other people, including many lawyers, who disagree with me, that it was a historic mistake. But contrary to what some people have suggested, I didn't sort of wake up on the day after the referendum and say, oh, I'm going to try and wreck this referendum. This was not at all. I just sort of thought to myself, well, this is a very disappointing outcome. I think we're going to regret it, and it is going to turn into a prolonged crisis. And that crisis isn't precipitated by me, it's precipitated by the very circumstances of the revolutionary nature of what this government is now going to have to carry out. So initially, I just went along with it. I tried occasionally by a few interventions in the House to persuade Theresa May to keep her options open. But it was quite noteworthy that as the months went on, her rhetoric became more and more towards a hard Brexit. I think that was probably to placate the ERG members of the Conservative Party, whilst at the same time, interestingly enough, although she made this rhetoric, she was actually trying for something quite exceptional. The deep and special relationship outside of the EU, significantly different, I should make clear, from what we've ended up with. I always thought this was going to be improbable to achieve because I didn't think the EU was going to give it to us, but that's what she was aiming to do. And my rebelliousness only really kicked in when I read the Withdrawal Act. In order to prevent a vacuum in our law on the day that we finally left the EU, the government had to essentially sort of it was called the Great Repeal Bill, but it wasn't the Great Repeal Bill, it was the Great Preservation Bill, which was preserving all this EU law so that there was some continuity afterwards. But at the same time, as always happens when you have a revolutionary set of circumstances, the poor government found itself having to do a massive amount of things, which means that they then started to take shortcuts, which was so that this legislation was riddled with Henry VIII clauses, allowing for primary legislation to be changed by statutory instruments. In some cases, actually statutory instrument on the negative procedure. And I thought most startlingly of all, because I don't think the government actually knew what it was doing at that stage as how you withdrew from the EU, there were even provisions in it which said that statutory instruments could be used to implement whatever withdrawal agreement had been reached with the EU without the need for any further primary legislation whatsoever once the Withdrawal Act was on the statute book. Now, I'd already, I suppose, got quite crotchety over the attack on the judges over the triggering of Article 50, when they had done a perfectly proper role and then been absolutely traduced for it, and most deplorable behaviour. I'd spoken out about that, so I was already probably a bit irritated. And I thought that this was really an appalling way of going about it. It meant effectively that if a government was ruthless enough, there would be virtually no debate whatsoever on the terms of actually leaving the EU, even though the government then backed off and said, oh, of course, we'll have some debates. And that was my first rebellion. My first rebellion was going about and persuading the House of Commons and the majority of my, enough Conservative colleagues to ensure a majority, that this was so unsatisfactory that it had to be amended. And I suppose because I'm a lawyer, I was able to identify the very clause which needed amending. It was only a very small amendment. Tabled the amendment, explained it, and then the government started to try to back off and said, oh, we'll give you assurances. I said, no, it's too late. We really cannot have this. And we voted and we won. And that was the first time that the May government was defeated over Brexit. Not, alas, the last. But that's what got me going. It was described at the time as securing a meaningful vote, but actually that's not really what the amendment was about. The amendment was about making sure that we could not leave the EU without further primary legislation to implement whatever agreement the government had reached as to the terms of our departure prior to the date on which we left. And that effectively gave you a meaningful vote. So that was the first amendment. Thereafter, I did cooperate with other colleagues. Now, did I persuade people in my speeches on the floor of the House to support me? It's possible one or two, although in reality, probably the majority will have been persuaded that it was the right thing to do before the debate started. But it's worth bearing in mind, particularly on the first rebellion, that there were people who were talked out of it rebelling or bullied out of it by the whips. Literally, as I was speaking in the chamber, I could watch it happening in the rows in front of me. So advocacy may play a role in this. And I was, at the end of the day, you want to try to explain issues as best you can. And so, yes, in those 2 years that followed, I suspect the House of Commons heard the sound of my voice perhaps too often. But things progressed on from there. Then there were amendments to try to make sure that the House could express its own view rather than just having motions in neutral terms. And by then we were in such a crisis, particularly within the Conservative Party. And the main thing was trying to make sure that one did all this while still maintaining relatively cordial relations with people with whom one disagreed, even though probably behind my back they may have been less cordial about me than when we were talking to each other. But I think it's quite important. You've got to maintain courtesies. And we succeeded, I think, broadly in doing that.
And you mentioned the whips there. Would it be quite pessimistic of me to say perhaps there's far more to persuade as a whip than there is as a backbencher making a great speech? Or is there still a role for great speeches? You mentioned Hilary Benz. Is there still a role for great speeches, or is it all?
Oh, I think there is still a role for great speeches. I think that if you are on a knife edge, as I say, most people are likely to have made up their mind what they're going to do prior to a debate taking place. And generally speaking, the House splits on party lines. But when people are rebelling or thinking of rebelling, then they will be swayed by hearing somebody with whom they may have been cooperating articulate a case. They may feel embarrassed about giving up on them. Loyalty can, be a very prominent feature. obviously there's the loyalty to the party, but there's also the loyalty to the colleagues who are putting their neck on the block and are going to rebel. And you know they're going to rebel, and therefore the question for you is, am I going to join them, or am I just going to leave them to rebel? And my experience is that then starts to breed its own loyalty ties, so that there came a point where, in fact, on the whole, if we were able to defeat the government, and of course the other great event was right at the end, before prorogation, which was the Benn Act.
Yes.
The Prime Minister had made absolutely clear that he was prepared to take us out with no deal on the 31st of October 2019. That threat was real, and therefore there was a coming together of quite a large number of people who didn't necessarily agree on everything, but agreed on that it was a very undesirable state of affairs, to plan and implement the Benn Act. When the government had done everything possible to try to make it impossible for us to do it before Parliament was prorogued. Now, that needed a lot of planning. Yeah. And I suppose coming back to your question about advocacy, or as a lawyer, the advocacy was in part the advocacy you had to deliver at meetings with people, which was, yes, you can do this. If we do 1, 2, 3, 4 things, will it work? Are we going to end up with egg on our face? Is it all going to go wrong? So in a sense, the advocacy was partly saying, as long as we stick together, we can deliver this outcome. And these are some quite esoteric areas, because a lot of it was about the standing orders of the House of Commons, subjects on which I should emphasize, I made no pretense then at being a sort of constitutional expert. But fortunately, the clerks of the House of Commons are always willing to help MPs on these issues. And it was, and they'll do that. They'll advise anybody on any side about this. And so one was able to go and speak to them. But the fact that I could usually understand what it was they were trying to explain to me meant that we were able to seize control of the order paper. Yes. Pass the Benn Act. Then, of course, we got prorogued, and there was nothing we could do to stop that, although that was eventually stopped by the Supreme Court. But they were fascinating. I mean, certainly they required applying some legal knowledge to doing it, but I was also helped by other people. This wasn't a solo, that end period was not a solo venture on my part. The earlier part of it probably was largely myself thinking, what is it we can do to try to stop this thing happening?
Mm-hmm. Recent decades have seen a decline in the number of barristers in Parliament. So 2 questions to finish on. First of all, why do you think there's been that decline? And I can guess the answer to this one, but do you think that that is necessarily a bad thing?
The reason for the decline, I think, is very easy to spell out. The ability to combine a really successful career at the bar with being in politics is now really impossible. Back 100 years ago, there were barristers who were working in court all day, just as the attorney I was describing working, and then in the evening would go down to the House of Commons and would stay till 11 p.m, midnight, 1 o'clock in the morning in debate, would go back to their homes and would be back in court the following morning. And the sort of work they were doing as advocates in court and the sort of work that was required of them as a member of Parliament made that a combinable activity.
Yes.
Quite apart from anything else, the idea that as an MP you had to go and spend large periods of your time in your constituency would not have 100 years ago have been regarded as necessary at all. And some MPs in those days were visiting their constituency a couple of times a year for a week. Otherwise they weren't there.
Yeah.
And the idea that they should be acting as a sort of local representative and problem solver stroke, in some cases, social worker, which is actually what a modern MP's role is, would have just been regarded as completely ridiculous. So as the MP, the politician's role has grown, it becomes harder and harder as I discovered when I got into the House in 1997, I didn't leave chambers, but my practice diminished. I was practicing a bit in vacation time. There were one or two members of the House of Commons who took their bar work more seriously than I did, and actually used to go and see the whips and say, I'm going to go away for 3 weeks to do a case somewhere. And the whips just had to lump it. But it didn't earn you brownie points for getting on in a political career.
Yeah.
Although it's true, I can think of one colleague who, despite that, has had a distinguished career in Parliament. But you have to make a choice. So that's why they're not there. So it's wrong to say there are not quite a few people who may have qualified at the bar, or indeed may have done a tiny bit of practice. But when you actually examine it closely, you will discover that they've been in Parliament for 15 years and probably they haven't been practicing for 20.
Yeah.
They've gone off and done something else before they went into the House of Commons.
Yeah.
So, yes, they will have some memory, but I don't think it's that of being really in practice at the bar. And that's why it's gone. Now, what impact has that had on the House of Commons? Yes, it's had a noticeable impact. I think there are fewer people around with a well-grounded understanding of what law is and the rule of law than there were previously. Parliament is much fuller of professional politicians, many of whom have really spent their entire lives and careers since leaving university involved in politics, and if they've not been in politics, they've been involved in public affairs or public relations. And this applies right across the spectrum. It's not just about barristers not being there, it's about all sorts of people, people with long experience of business. There are exceptions, I should make that clear. Even, and I mean the tradition which used to exist in the Labour Party, that there were members of the Labour Party who had been manual workers. You know, they might also have been trade union representatives, but they genuinely were people who had spent time on the shop floor. Yeah. I mean, this is now a distant memory. I don't know if there's anybody left in that category at all. So I think the House has lost out as a result. That said, I think there's a certain inevitability about it, because I don't really see how it can be readily reversed. And the example of the problem can be seen from the fact that under Labour, under Tony Blair, they had to encourage lawyers to be willing to go into the House of Lords and become Attorney General. So under Labour, Lord Goldsmith and Baroness Scotland were all members of the House of Lords. Yeah. Really, because there was, in truth, admittedly, they did find somebody to act as Solicitor General and be in the Commons. You had to have somebody to answer for the department. But they couldn't really find anybody they wanted suitable on their own benches within the House of Commons to do the work.
Yeah, yeah. It's interesting to hear that, and it's interesting to consider the future. Obviously, the students who are currently at the bar, who one or two of them might be thinking about political careers and balancing the law and politics. Just as a very final note, because you've been extremely generous with your time, would you encourage them to do so?
Yes, I would. And I would say to them, come to the bar. The chances are, if you qualify for the bar by the time you're 23, 24, very few people go into the House of Commons in their 20s, and I'm not sure it's a very good thing. You've got 10 to 15 years of practice, unless you're very lucky, which you can combine with being interested in politics. All right, politics might snaffle you early. So you only have 7 or 8 years in practice at the bar, but it is combinable. And it does have the added advantage, which I'm the beneficiary at the moment, that when you finally get slung out of politics, there is something to go back and do. Although that will be variable according to what the state, how much career you had before you went in, and one's got to acknowledge whether you keep a link to a set of chambers and they're able to go back into them. But it does provide some flexibility. I certainly think it's a good grounding for going into the House of Commons. And I would just recommend to people, just don't be too impatient, because one's career is when you start out on a career, you tend to be quite impatient. You think, I've got to be reaching all these targets very quickly, and I don't think you need to do that. And if you can develop a good career at the bar, of course, it may be that the career at the bar proves so enjoyable and, dare I say it, remunerative compared to what you're going to get as a member of the House of Commons, that you may decide to change your mind about give up your political career. That's always a possibility, but at least you will do it freely and without a sense of guilt about it. But alternatively, you may find that you can combine the two, and it's certainly worth doing.
Master Grieve, we've come to the end of our time. You've been so generous, but thank you so much. We've covered an awful lot of ground, and I hope that everybody who's watching will have found this as captivating as I have. It's been fantastic. Thank you so much.
Thank you.